Good morning, everybody, and welcome. On behalf of the Real Estate Board of Greater Vancouver, I'd like to thank you for joining us today. I'm your moderator, Josh Bath. I'm a realtor with Keller Williams Elite Realty, and coming up in 12 more days, I'm going to be at my 29th year in real estate. Our event today is Boundaries Between Strata Corporations and Short-Term Rentals. Before we begin, I'd just like to say, please hold off on your questions until the Q&A period at the end of the presentation. If you look down at the bottom of your screen, you'll see the chat function, which you're all using perfectly. And a little further over, you'll see a Q&A bubble. That's where I would love for you to put your questions in there, and then we'll have a look at them and get to them. And if time permits, hopefully we'll get to all of them. So keep your questions clear and concise so that we know exactly what it is you're looking to ask. Now it's time for me to introduce our panel. First, I would like to introduce to you Claire Thompson, and Claire is the manager of proactive enforcement with the City of Vancouver's Development, Buildings and Licensing Department, DBL. Claire's team oversees business licenses, compliance and enforcement for short-term rentals, as well as the higher risk properties in Vancouver, including single room accommodation buildings and vacant properties. Prior to her role at the city, Claire has held investigative and leadership roles both at a provincial and federal government levels. Claire holds a master's in science, in forensic science, as well as a master's in business administration. Claire has held various volunteer roles within the community and is currently on the board and vice president for Turning Point Recovery Society. I'll turn this over to Claire. She has a great little video for us to start this off, and off we go. Claire, welcome.
Thank you, Josh. Oh, thank you, Josh. We'll just wait for the video to go. Just a quick little 1-minute snapshot. There's no sound. Are we able to get sound?
I imagine they're working on it right now for you.
Okay.
Yes. Yeah, you bet. Or you could ad lib. That would be fun.
That's true. There's some rental and vacancy considerations going on in this video. It's really talking about the reason for short-term rentals in Vancouver and when they were enacted in 2018. It was done to support many different initiatives in the city, but certainly one of them being the protection of the long-term rental supply and allowing people to earn additional income, but also ensuring that they were in compliance with the regulations and that there is a team of people here to enforce when people are not in compliance. So I can send the link after where you could listen to the video if you'd like. We do have additional videos to ensure that everyone knows about what's going on in the short-term rentals here in Vancouver. So hello, my name is Claire, and that was the video that had no sound.
Just for the record, Claire, just for the record, it's a great video. So everyone should take the time to go and watch that one. It's really quite good.
Oh, thank you. It's just wanted to make sure that it's simple. We fully understand that bylaws are complex. There's a lot of different considerations across different cities going on throughout the province as well. So that we want to make sure that they're easy to understand. And we fully recognize the importance of you all and the communication chain, importance of what you represent in communicating with the public and the different conversations going on in the community. So I just want to quickly give a quick 101 on what is and isn't allowed in Vancouver in regards to short-term rentals. I know many of you have been here before. We have been at these presentations. So the really major consideration around short-term rentals is that it must be someone's principal residence. And what that means is that someone must live in that unit. It doesn't mean that they could live there if they needed to. It doesn't mean that it's a nicely furnished place that doesn't actually have anyone living there. It's truly where someone lives, they call home, and they're really a part of the community. So what that means also, it's not the investment property. It's not an empty condo in downtown Vancouver. It's not an empty laneway house or secondary suite either. So if someone lives in the main house, they're not permitted to do short-term rentals in the laneway house if they don't live there. And it must be a legal dwelling unit. So that's a really safety consideration, is that it must be in compliance with all the bylaws in regards to zoning and development in the building bylaw as well. And if someone lives there, they are able to get a City of Vancouver short-term rental business license. And that license has some considerations around it. That you must have landlord approval. You must have strata approval, which we'll go into more in depth throughout the presentation here. But it's an easy process. It's online, and it just takes a couple seconds to ensure that you're in compliance with all the regulations. And then you get a city business license, and you put that license number in the marketing of all short-term rentals. So we also have a prohibited buildings registry in regards to stratas. So when there's buildings that don't allow short-term rentals and they have explicit bylaws that prohibit short-term rentals, they can let the city know of the addresses of those strata units, and we will ensure that no one within those units are actually issued any licenses. We just want to make sure that everyone's in compliance, certainly with our bylaws, and we do our best to work with stratas as well to make sure that they're in compliance with their own as well. So as I mentioned, there's a number of different initiatives that short-term rentals help support. They are very polarizing. We fully understand from a city's perspective that some people want them. Some people are completely opposed to short-term rentals within the city. And even within those sort of considerations, people want them to be more prevalent and allowed in short-term rental, in investment properties. You know, the regulations were enacted by council. They're there to support a lot of different initiatives. So we do ask that everyone sort of really understand what they are. And if there's any concerns or questions about it, please feel free to reach out to the city anytime. We do have an enforcement team that is really dedicated to making sure that everyone understands what's going on, and we work closely to work with lots of different stakeholders to understand what people want and what's missing out there. Also, our team is really great at their job in regards to enforcement. We have had a lot of success in regards to making sure that we have compliance throughout the city. And when that isn't obtained, we actually do have people that have warrants out for their arrest. We work with the city prosecutor's office, and when they have not showed up to their court date, they have been issued warrants for their arrest for doing illegal short-term rentals. So it's really important that everyone knows that we take this very seriously as a city, and that it's safety. It's there to make Vancouver a welcome and safe place for people to stay. So that's sort of my quick bit.
Oh, you're not done yet. I've got a couple of questions here for you. Thank you for that, Claire. I appreciate that. There's a question for you. What is the minimum amount of days as far as the city of Vancouver is concerned to make it a primary residence in order to be eligible?
So there's no minimum days that someone must stay in their unit. So that's different than the empty homes tax consideration from the city and the province with speculation tax. There's nothing in regards to the short-term rental bylaws that state there's a minimum or maximum number of days. So it's really case by case. We take all things into consideration, whether it be through community complaints and things like that. If someone says that they don't live there, we really have those specific conversations.
Of course. Okay. Thank you for that. Is there a list of buildings that are prohibited available to the public?
Right now, it's not publicly available. It's something that we're considering. We're working with our privacy office. There are some considerations around releasing that type of information publicly. If someone were to contact the city, we could let them know if it was on the prohibited buildings registry. So they would just need to contact us directly. But right now, it's not publicly available.
Yeah, okay, that's perfect. What other, a question coming in here for you as well, what other cities in Canada have similar short-term bylaws available to them?
It's a good question. They're all, it's a mixed bag, in all honesty. Many have enacted regulations within the past year or two. The city of Vancouver was one of the first to actually do an enactment of regulations specific in regards to short-term rentals, but Toronto, Montreal, Calgary has enacted them. Squamish has just done them recently. I think Burnaby is in the consideration of it right now. So a lot are in different timing of it, but I believe that many have adopted them or will be in the very near future.
Got it. Oh, okay. Yeah. So Abbotsford, Chilliwack, those are cities that are probably Maple Ridge, Pitt Meadows.
Yeah, the Valley ones I'm not sure of. I know Kelowna, it really is. It really depends on the community specifically, and
Sure.
the prevalence of them. There's some communities that it's not a big deal. I know New West has adopted them. It sort of coincides a lot with tourism or lack of hotel spaces and things like that as well. So it is very, very community specific, and I really do encourage you to reach out to those specific municipalities. I wouldn't be able to speak sort of confidently on what they have adopted or not.
No problem. Roger's asking, he wanted to know if you heard this right, that tenants can register a short-term rental if the landlord agrees and lives in the building?
So a tenant can be a short-term rental operator. That is correct. The landlord doesn't have to live in the building. They just need to have the landlord's approval. So if someone lives in, they're renting out a condo unit downtown from someone, and the condo unit owner and the strata allow short-term rentals, they can do short-term rentals as a tenant. Yes.
Okay, all right. And then fascinating, actually. Carrie's asking, so if strata says no short-term rentals, there's actually no time restriction on that? I think I understand that question. Did that make sense?
I'm not sure about the time restriction. If the strata says there's no short-term rentals allowed, then they would not be authorized to do short-term rentals from a city's perspective.
Sure. Yeah.
An individual needs to be able to produce a document to support that they actually have the strata's authorization. So it's not just saying it's in the bylaws. They need to be able to produce that document.
Got it. Okay. Alan's wondering, again, it's back to the primary owner residence. So did you say it must be the owner's primary residence to qualify for the ability to short-term rental?
It can be the owner or the tenant. So if someone's renting out the laneway house and the owner lives in the main house and they have a long-term renter in the laneway house, the tenant can rent out the laneway house for short-term rental. So it could be the owner or the tenant.
Okay, right. And of course, the tenant with the owner's permission.
Yes, yeah.
Got it. Okay. Mandir wants to know, what is the shortest period and longest period considered for a short-term rental? Has that been defined?
Yes, sorry, and that was in the funky little video in the beginning, and I forgot to bring up. It is under 30 days. So anything over 30 days is not considered a short-term rental. There is long-term rental licenses that people need if they're going to be doing longer stays, which may include sort of 2 months. That's not considered a short-term rental.
No, now you're getting into rental. Yeah. Okay.
Yeah, so it's under 30 days.
Cost of short-term operator's license.
Good question. It is $99 for this year, and it will be going up. Council just approved a business license increase for all business licenses across the city of Vancouver, and it will be going up to $104 for 2022.
Okay. Okay. And now Tikal is asking, how is it that the detached home with one PID cannot short-term their suite? That makes sense.
PID, what was the PID? So with one
parcel identifier.
Oh, okay. So, and that's some of the nuances. Short-term rentals are defined by the specific unit. So empty homes tax, and this is where some of the things, the boundaries overlap and get a bit confusing for folks, I think. Empty homes tax is a parcel. And so if someone lives on that parcel, that's their declaration. However, short-term rentals are the units. So if you have 3 units on a parcel, you have a main house, a secondary suite, and a laneway house. Each of those are 3 different specific units. And it's really, a lot of the initiatives that the city has done, specifically allowing laneway houses in the city, has been done to increase the rental supply, the long-term rental supply in Vancouver. So this initiative helps support that. It's really to ensure that we have enough places for people to live in Vancouver primarily.
Okay. Okay. There's quite a few questions coming in for you, actually. So, but I'm gonna cap it off at one more, then I'll move on.
Okay.
There is Jimmy's wanting to know, I have yet to see any strata that allows Airbnb type very short-term rentals. Is there at least one condo development that allows short-term rentals that you're aware of?
I'm aware of many that do. So I'll allow you all to do the research out there yourselves, and ensure, but there's many throughout the city of Vancouver that allow them for sure.
I thought that was a great answer. Good. Yes. So they do exist. Go find them. They're out there. So here's my question for you. So you've modeled this. This is a great thing to do, I think, really, in terms of really making sure that things are being done properly and correctly. You're modeling this and sort of trailblazing. Are other cities coming to you right now saying, can we sit with you, brainstorm, mastermind around best practices, what worked, what didn't work? Are you getting that?
Yeah, no, it's because it's so new, and Vancouver has, we led the way primarily because we also had we had some major rental issues going on in Vancouver. So, you know, some of it was necessary and some of it was because the great work done by the city. It was enacted before I got here, so it wasn't sort of to toot my own horn. But yeah, many municipalities are figuring out the best way to implement their own regulations. It is complicated. We are very fortunate. We have an MOU with Airbnb specifically, so we get information from Airbnb on a monthly basis. They want to make sure that all their operators are in compliance as well. And that's something very unique to the city of Vancouver. At the time, it was a first of the kind, and I think they may have a few more across the country now, but and that's one thing that other municipalities sort of want to better understand how enforcement's done, the best way to educate people on what works.
Okay, all right.
Yeah.
And would you think that extra insurance would be required if you're going to have a short-term rental as well?
That I'm going to defer to Lisa or Tony on, if they might know a bit more about that. We don't sort of get involved in regards to insurance. We want to make sure that everyone has the appropriate steps in place and documents, but in regards to specific insurance policies and what's required, that's not something that the city jumps into.
Well, thank you for that. I'm going to say fantastic job, Claire. Well done. And way to keep us wanting more with that video. So we're all going to click on that later on today. Thank you. I appreciate it. I'm going to introduce the other two panelists now, and then we'll have you back on shortly after.
Sounds great.
Thanks. Okay. So now it's on to our next two panelists. I'd like to introduce them both because they're going to be presenting for the most part in tandem on a panel. For the person that requires probably the least amount of introduction, our Iron Man of panelists, Tony Gioventu, as we all know, is the Executive Director of Condominium Home Owners Association of BC, also known as CHOA, a consumer association in British Columbia with over 200,000 members. I am one of them. Comprising of strata corporations, owners, business members, realtors who serve the strata industry. In addition to serving on numerous boards and committees for government agencies and industry associations, Tony is the weekly columnist for The Province, The Times Colonist, and syndicated media across BC. Since 2002, Tony has written over 1,000 columns and counting, I'm sure, and information bulletins dedicated to condo living, and is the co-author of the Strata Property Act, A Practical Guide to Bylaws and Understanding Governance, Strata Rules of Order and Procedure in British Columbia. I kind of ran that one on. Sorry, Tony. Those are two separate co-authors. Please welcome Tony Gioventu, and hold your applause before we go too deep in. Let's also welcome Lisa Mackie to the panel. I believe this is your first time. Lisa, have I got that right or wrong?
It is. Yep. Yep. Excited to be here.
It's exciting to have you here. For everyone here, Lisa is the leader of the Strata Property Practice Group and Rental Property Group at the Vancouver-based law firm of Alexander Holburn LLP. She has represented clients from before all levels of court in British Columbia on strata property and residential tenancy matters. Lisa also represents and advises clients on human rights complaints, privacy disputes, employment disputes, and defamation matters. Lisa has earned significant recognition in the legal industry and has been a trusted legal advisor for various print and television media publications on strata property and residential tenancy issues, including CBC, you've got a good one, Lisa, CBC Radio, CBC News, Canadian Lawyer Magazine, Canadian Apartment Magazine, Canadian Real Estate Wealth Magazine, City TV Breakfast Television, Times Colonist, Metro Vancouver, The Province, and Canadian Property Management Magazine. Please welcome Lisa Mackie and Tony Gioventu.
Thank you for having us.
So Lisa, we were going to start out with a little bit of a banter about short-term accommodations.
We are. Shall we begin our banter, Tony? What do you think?
Well, I think the first thing that we need to, and this is partly the language that's being used, but we caution everybody to refer to it as short-term accommodation, not a short-term rental, because what we're seeing is that buyers in new buildings are confusing short-term accommodations with the owner-developer rental disclosure, thinking they're exempt from the bylaws.
That's right. And actually, I run afoul of that rule as well, Tony. So you and I have chatted about short-term accommodations over the years, and I use the phrase, as everyone does, short-term rentals. And the spoiler alert, it's not a rental under the Strata Property Act or the Residential Tenancy Act. So when it comes to enforcement or understanding how to regulate the activity in strata corporations, whether it's the strata corporation that wants to prohibit or regulate, or if it's a strata lot owner that's renting out their property that wants to have that control as well, it's important to get the lingo right and to understand where you go for enforcement. So yeah, that's key. Absolutely.
Yeah, and we find that causes quite a lot of confusion for investors. That's one of the big challenges. And I think they can sometimes be misled about what the intent is and not realizing that there's every good possibility that strata community might pass a bylaw that just simply prohibits short-term accommodations.
Absolutely. And it's within a strata owner as well, within their rights to prohibit the activity in their own tenancy agreements as well. So one of the questions this morning that cropped up, can a tenant do this? Strictly speaking, yes, but the owner as landlord has the control, as well as the strata corporation. If that property is in a strata corporation and there is a bylaw in the community that prohibits the activity as well. So a lot of confusion out there, a lot of misunderstandings with respect to what kind of bylaws are needed, or what kind of language is needed in a tenancy agreement to regulate this. As many of you guys will know, but the stratas by default will get the standard bylaws appended to the schedule of the Strata Property Act, and they are silent with respect to this activity. Now, the law changed in 2018 to allow strata corporations to pass their own short-term accommodation bylaws. Now, the legislation calls it short-term rentals as well. So, but we want to avoid that rental language. And they allow some steep fines, so up to $1,000 a day. But I don't know about you, Tony. When I see a lot of bylaws out there, or a lot of the bylaws that the communities are relying on to regulate the activity, I see a lot of problems.
Yeah, the bylaws themselves are not well written, and the enforcement of them is complicated, and the record keeping is not managed properly, and the strata corporations are not following up with the proper notice to the owner of the unit under the short-term accommodation that they may be in violation. And so, you know, you have a short-term tenant this week. There, I just did it. I called it a short-term tenant.
We all do. We all do.
We all do. But you know, they you know, they have a bylaw, but they have a short term that was in this weekend, and there was 3 days. $1,000 a day is potentially $3,000 worth of fines, and it really does matter to an owner investor. The other challenge we have, of course, is that, you know, while the city of Vancouver requires occupancy of the unit with respect to the short-term accommodation, we have multiple investors out there who own many units within their building, and they're just renting them out as Airbnb, as short-term accommodations. And, you know, from municipality to municipality, those regulations and bylaws vary greatly.
Oh yeah, absolutely. And no community is the same. And so I think when we're looking at advising our clients and purchasing into a community, we need to look at what those bylaws specifically say. Or if you're purchasing a property that is under a tenancy agreement, knowing what your client's rights will be in terms of enforcing those activities. And so you can't knock on the CRT's door, you can't knock on the residential tenancy branch door unless you have the tools in your toolkit to be able to regulate the activity. And that's key. I've seen a lot of people just fall flat of having the appropriate language in their bylaw or in their lease agreements to actually regulate the activity, or councils that just aren't sure what to do or how to actually begin, where to begin, frankly.
You know, a common complaint that we've been getting in the last 6 months to a year, and we've seen short-term accommodations really dip down because of COVID. There've been far fewer travelers, but a common complaint is from property managers and strata councils that the short-term accommodations that are either permitted and are chronic, or that are not permitted, add a huge workload to what is already a substantial workload for a volunteer strata council and property managers, which is often one of the motivating factors for wanting to prohibit them in the first place. Because the owners of the units are just not behaving reasonably. And there's all kinds of problems. There's security problems. We're dealing with bylaw violations, building access problems, personal property damage. There are significant issues that arise from these multiple short-term accommodations. Somebody raised a question though about insurance. And one of the issues we've seen is the insurance companies, the brokers specifically on renewals of insurance, are now asking two questions. Are there rentals permitted in your building? Are there short-term accommodations permitted in your building? And this is having an implication on the renewals and on the cost of the insurance and the deductibles, which again, I think strata corporations are going to have to start looking at.
Absolutely. And as a homeowner to start looking at as well. So from your own personal, your own homeowner's insurance, when you're changing the use of your property, when you are introducing a commercial activity or a hoteling activity, it's called in lawyer speak, a material change in the risk. So we do have a duty as owners, if we are allowing activity and subject to what the strata corporation says, we have a duty to report this change in use to our insurance provider. And worst case scenario, if an incident happens, so somebody is injured or property damage occurs, you might be without insurance coverage if you didn't properly notify your insurer as to what you were doing at the property. So major fallout for owners. And I've seen countless times where owners think they can rely on the third-party provider, whether it's Airbnb or VRBO, to be able to use their insurance protections there. But there's a lot of exclusions in those policies. And so, in terms of the initial dialogue as an owner, to have the discussion with the strata corporation as to whether or not this is a permitted activity, but also to have the discussion with the city, as we've learned from Claire this morning, as well as from our insurance provider.
Yeah, the other implication, which has become really prevalent, especially in some of the downtown core buildings, is if there is a claim resulting from a short-term accommodation, most of them tend to be where it's an absentee landlord. It's not where they are in situ with a resident owner, but it's an absentee landlord. And it's fine to say that the strata corporation's insurance will cover the claim, but the implications of that for the next 5 to 10 years are really weighed down by the strata corporation and all the remaining owners. Those claims will result in a chance that they may not be able to renew their insurance, or much higher deductibles and much higher insurance costs. And you're right, the short-term organizations don't cover the strata corporations. Their coverage is for the owner of that unit if they've met the conditions of that coverage. It doesn't consider those future implications that really have a significant impact on the cost of operating that strata.
Yeah, there's a lot of factors there. I think that it's important for, if anybody is considering engaging in this activity, and we understand through the city that they want to foster additional means of income, and they want to keep long-term housing available for tenants and potentially allow them to get some revenue from this. But there's a lot of risk that's associated with the activity that needs to be considered here. Tony, should we launch our first poll maybe?
I think so. I think it's time to get into the poll questions and give everybody a little bit of a test.
Okay. All right, so we'll have the first poll question up for grabs. And
Cheryl, we're ready for you. There we go.
Okay, so I'll read out the scenario. Tranquility Estates uses the standard schedule of bylaws to the Strata Property Act. And I should say, if your place is called Tranquility Estates, you're lying. There is no tranquil strata in the city. Recently, the council has received complaints that 3 of their residential strata lots are operating short-term rentals in breach of city licensing requirements, including the unit owned by the strata council president. There have been complaints for the short-term renters, or that the short-term renters have engaged in raucous parties, much to the chagrin of the neighbors, none of whom were invited. The council has decided that because they do not have a short-term rental prohibition, they can't stop the activity, and they are leaving the enforcement up to the city. So the question for everybody is, can Tranquility Estates leave enforcement to the city? Yes or no? What do we think? So our poll's open. We can see some activity here. We'll give it a few more seconds. 50-50 shot, everybody. This is probably, this is better than Vegas odds, so.
So just a little tip to everyone, don't start taking the poll till the question is done. Otherwise, you're almost guaranteed to get it wrong. So.
All right, well, let's end the poll and share the results. So we're all over the board. We've got 63% are saying no, that the strata should not leave enforcement just up to the city. And about 40, almost 40%, 38% are saying yes, you could leave enforcement to the city. So I'm going to pass the mic over to Tony first. What are your thoughts on these results?
Well, I think the answer is maybe, not actually yes or no. And the reason being is that, yes, the city can enforce with respect to any of the regulations that have been violated by the owner of the units. But when it comes to the strata corporation and things like noise, security issues, other items that may have caused a nuisance, or any violation of the strata corporation's bylaws or rules, it's going to be up to the strata corporation to take a direct hand in those and enforce those bylaws. And that's where I think sometimes strata corporations kind of step back when there's a city regulation and think, you know, someone else is going to manage this. That's not going to happen. The strata corporation is going to have to be proactive in the enforcement of their bylaws. And yes, they are going to contact the city and probably file a complaint if there are actual regulations that are being violated. And again, it's going to depend on which municipality you're in. Some municipalities have no regulatory impact when it comes to short-term accommodations. So add your 2 cents there, Lisa.
I will. So yeah, I mean, I totally agree with you there. I think it's one thing to say that the city has enforcement powers, but we can't ignore our own as strata corporations. We have a duty under the Strata Property Act to enforce the bylaws and to make sure that we manage the common property in a manner that is in everyone's best interest and ensures the safety and security of the building. And based on that story, we've got a lot of disruption that's occurring at the property. And as you say, Tony, that's going to be captured somewhere under the bylaws, even if they don't have their own specialized bylaws to prohibit the activity. They certainly have bylaws that regulate property use, nuisance, disruption. And the buck stops as well with the strata. And in the event that the strata ignores the activity or ignores owner complaints, and in particular, we have a precarious strata council president that's sitting out there on the ledge that is potentially involved in the activity as well. They might be on the receiving end of a complaint at the Civil Resolution Tribunal for not doing their job, so to speak. So it's both something that the city needs to dial into and the strata as well.
Yeah, I think the other challenge that we see quite frequently is kind of the imposition of Airbnb or, you know, VRBO, whatever they are, where there's an absentee landlord who's renting multiple units. We get noise complaints chronically. We get security issues that occur, and what often results from one of them, and we certainly saw a significant increase of them, you know, when we go back to 2018, 2019, are damages to property and damages to facilities that might be gymnasiums or swimming pools, and these are being, you know, basically generated by the visitors who are using the facilities as Airbnb and all of their guests. And, you know, it's not that there shouldn't be short-term accommodations. They definitely serve a valid purpose, but the behavior that goes unchecked is the problem that these communities are having. And the strata corporations start to have a really difficult time trying to deal with these damages and the costs associated, because they may not have any way of identifying who actually did the damage, and that's a growing issue, which has compelled a lot of strata corporations to put video surveillance within their public areas, and that comes with its own little degree of problems as well.
Yeah, I think stratas have got really creative in terms of enforcement and busting people for using their properties in violation of a short-term accommodation bylaw, or trying to regulate the nuisance causing behavior, or address the property damage, investigate that. And in addition to the Strata Property Act, in addition to the bylaws that we have to know for our municipality, we also have privacy laws that are in place. So in our province, the strata corporations are bound by the Personal Information Protection Act. It's PIPA for short, but it regulates how far stratas can go to collect personal information, to monitor or surveil the property. So video surveillance is considered to be one of the most invasive invasive ways of information collection because it monitors activities. Folks have been held accountable for using fob records to track fob use, potentially disabling fobs in an effort to curtail unauthorized use of a property. And so there are these other considerations that are in play where stratas need to probably get advice in terms of, can I use this as an enforcement mechanism? Can I put a camera up? And if I can, how do I go about authorizing this in the community?
Yeah, you know, another thing that when you look at strata bylaws where they have recreation facilities, and this kind of ties into this scenario, is many of the bylaws that deal with recreation facilities like swimming pools or health clubs or saunas or whirlpools. If you read them closely, many of them say an owner, tenant, or their guest who must be accompanied may use the facilities. If you have an absentee situation with a short-term rental, they're not accompanied. They've basically been given the keys to the palace, and they're allowed to wander pretty much throughout the buildings and use the facilities. And that's where I think an investor, an owner who's actually renting their unit out for short-term accommodations, I think this is where the owner really increases their personal liability quite substantially.
Oh, 100%, absolutely. And I think the burden on the strata as well to make sure that we keep track of those keys or devices or access. I mean, it's especially challenging when we have those disinterested landlords that are not paying attention or moderating who's using the property. I've certainly encountered, nobody likes to ring a lawyer. No one wants to talk to a lawyer. And so I only hear bad news at the end of the day. No one calls you with good news. Here's a great rental scenario that I've encountered. But no, one of the most common has been that absentee landlord who is allowed, or, you know, unbeknownst to them, a tenant has been using their property as a hoteling operation and has been copying keys, and keys have gone missing. And that opens up a huge security risk for the building, mismanagement of recreational facilities. It can be an absolute nightmare.
I was going to say I was involved in an AGM for a strata downtown Vancouver last week that tried to get a ban on short-term accommodations passed because they've been having so many problems with the issue. And the difficulty is 3 individuals held enough proxies to block the passing of the bylaw, but the reality was those 3 individuals own enough units in those buildings that they are not resident owners, and so they're going to basically run afoul of the city bylaw as well.
Yes.
Which I think the Strata Corporation probably needs to step back and involve the city in the enforcement of this at the same time.
Yeah, absolutely. And that's actually a good tip. And I think it's a useful reminder. And I'm glad that we have Claire here today to talk about their enforcement mechanisms and how far they can go in terms of issuing arrest warrants and what have you. But the strata, you are not alone in this. And as an owner, you're not alone in this either. There's a lot of other entities that can help with that enforcement and the regulation beyond the 4, walls of your building. And so using those resources is key as well.
Josh, did we have any follow-up questions to this topic before we get into the next?
Well, we do, as a matter of fact. We have many, but if I were you, I would carry on with the poll, and we'll cover these questions because there are quite a few.
All right. Okay. Well, poll number 2.
Let's go with poll number 2. So if we could get some tech assistance with getting that up and running.
And don't answer the poll until Lisa finished the question.
It could be quite sneaky when you want to jump the gun. Okay, so here's the next poll. So Paradise Pier is a residential strata located in Vancouver, BC. The community has 3 bylaws that it deploys to prohibit hoteling operations. And so far, their bylaw enforcement has been no vacation. Here are their bylaws. So bylaw 1, no strata lot may be rented for a term of less than 30 consecutive days. Second bylaw, no strata lot shall be used for any business purpose whatsoever without prior approval by the council and the city of Vancouver. Bylaw 3, no owner shall rent all or part of their strata lot or permit all or part of their strata lot to be rented. So the question of the day is, which of these bylaws regulate short-term rental accommodations? Is it bylaw 2, bylaws 1 and 2, bylaw 3, or none of the above? And so we've got some activity going on. We'll leave the poll open for a few more minutes. We're really putting you guys through the paces this morning. I hope you did have coffee, because this would be pretty brutal if you're uncaffeinated right now.
And they are kind of trick questions too.
They are. I know we're very tricky people, Tony, I think.
And on another note, Lisa, I always like talking to you. We always have great discussions. So our lawyer client relationships always work that incredibly well.
Well, you have to inject some humor in this. If you're not, you're quite miserable, frankly.
Exactly.
But, yeah. Okay. So let's end the poll. It looks like some of the traffic has died down, and let's share the results here. So we're kind of all over the map again. So we've got about 13% saying Bylaw 2 is our ticket to regulate. 58% of use of the majority view are saying Bylaws 1 and 2 are good. About 12% says Bylaw 3, and then 17% says none of the bylaws. So what do we think?
Yeah, no, it's interesting. I think this is where we get into the difficulty of strata councils and property managers importing bylaws from other strata corporations.
Yes.
They run rampant. It's kind of like the broken telephone scenario. They run rampant throughout our communities, and not realizing that for a small investment, they could have gone to one of the strata lawyers and probably ended up with a decent enforceable bylaw. But the reality is every one of these bylaws is going to be very difficult to enforce because it doesn't explicitly prohibit short-term accommodations.
That's right. So those of you that said none of the bylaws, well done. And that's true. Not one of these alone or even together arguably regulates the activity. So in terms of some breaking news, in the event that you didn't know this, but the court has weighed in to whether or not pure business purpose bylaws, so that's Bylaw 2 in our scenario, whether or not they capture short-term accommodations. And the Supreme Court has said no. They don't consider this to be a business. It might be a commercial activity, but not within the business as defined in their understanding. And the problem with that one, and that's actually a replication from the bylaw that was found to be unhelpful for that community. The court sort of lectured the community and said, if you want to regulate this activity, you need to be explicit and you need to specifically craft a bylaw that makes it clear that short-term accommodations are prohibited. Advertising your property for a short-term accommodation is prohibited. Using your property for vacation use, timeshares, any imaginable use that you want to regulate has to be spelled out in your bylaw. And if it's not, you're out of luck.
Yeah, and again, this goes back to the same issue that we have with this generic understanding that every rental must be 30 days or more, or cannot be less than 30 days. It's an attempt to redefine what a rental is under the Strata Property Act or the Residential Tenancy Act, which has nothing to do with the short-term accommodation. That's one of the problems I think that we have, is this misconception of a minimum period of rentals. It doesn't impact short-term accommodations. And you're absolutely right. If you want to prohibit one of these activities, you have to very clearly articulate that in your bylaws.
Well, and the same thing goes for that property owner who is renting to their tenant. What does your lease say? Because the Residential Tenancy Act doesn't help you there. And the prohibitions or limitations on whether a tenant can assign their lease to someone else or sublet their lease doesn't count either, because it's not a rental. What the tenant would be doing is not assigning or subletting to somebody else. It's not a tenancy. So for owners out there that are having properties for investment purposes that want to rent out to long-term tenants and tenancies, you want to make very, very certain that the tenancy agreement you're relying on explicitly prohibits a tenant from doing this, because the branch will turn you away unless it's very, very clear in your lease that it's prohibited. Then there's not much that the branch can do for you. So you have to make sure to protect yourself there.
Just going back to 2010, 2011, there was a rental company, a real estate office rental company, who were basically acting as agents of owners, and none of the owners had put anything within their rental agreements with the company acting as their agent with respect to short-term accommodation. And unbeknownst to them, this company was representing about 125 units that they were running through Airbnb and short-term accommodations, with disastrous results for everyone except for the company, who was grossing, who was substantially grossing significant amounts of revenue above what they had committed to the owner of the unit. And so, as a landlord owner, you need to be incredibly careful about what type of permission and the conditions of your lease.
Absolutely. And you have to pay attention. Another issue that the branch encounters is we will have these uninterested landlords that jump in after months and months and months of the activity, and the branch will say, well, you didn't step in right away, so you mustn't consider this material to your lease. And they kick it out for that reason, saying that if you were actually paying attention to your property, then maybe you would have jumped in earlier. So lots to consider there. So we have a final poll question. All right, and again, just as a word of caution, we want to make sure that we listen to the full question beforehand because they're tricky. Okay, Look-See Towers uses a key fob system as part of its building security. The system is used at the lobby, parkade, elevator, bike storage, and fitness room. The council keeps an inventory of all of its key fobs, which links each key to a particular unit. The system records when and where each fob was used. Look-See Towers has a registered bylaw authorizing video and fob security system for the purpose of building security and bylaw enforcement. It also has a short-term rental prohibition. When a unit has been found in breach of the short-term rental bylaw, the council disables the fob's elevator access to block the unit's access to a strata lot or common areas. So the question of the day is, does Look-See Towers have the authority to disable fobs and keep their premises under lock and key?
Oh, so this is the million-dollar question, right?
Isn't it? Yeah, at least. We'll leave the poll open for a couple more seconds. Looks like we have some answers in here.
It's interesting what strata corporations think they have as a mechanism for enforceability, and oftentimes may exceed that, and frequently they will, because they don't want to go through the work associated with actually enforcing bylaws.
Yes. All right, so the poll is being relaunched. We had some technical difficulties there. Here we go.
There we go.
I was thinking it was radio silent at first, and I was getting a little bit concerned that we've scared everybody away and they've decided to change careers. So don't leave us just yet.
Yeah, Cheryl, it looks like the poll is frozen again.
I hope that's not me messing with it. So I'm going to stop touching my mouse and let it go.
Josh!
Yes.
Just to note, I'm not doing anything on the back end.
It's working fine now.
Just
Okay, so
nobody
Josh
look
is-
at it. Nobody look at it right now.
Yeah, Josh
So
is
the
making
next-
Hands
you.
up. Hands up.
So the next question should be, should Josh have access to the...
That's right. Let's do a poll of that.
First poll ever to get a unanimous answer.
Feel free to fill the chat, everybody. I think that's what we learned. All right, so we're almost there. We've got lots of activity. Let's share the results. So we have a resounding no from everybody, that there is no authority to disable the fobs. And so Tony, over to you. Is our crowd on the right track here?
Well, yes, they are on the right track with respects to the access of the main entrance and to the elevators and to the units. Strata corporations cannot for any reason prohibit or restrict access. The only thing that could arise that would permit that is if they had a court order in their hands,
Yes.
that permitted them to do this because they've evicted someone or had someone removed from the building. That would be the only possibility. Strata corporations, however, if they have recreational facilities and the party has violated the rules or bylaws associated with those recreational facilities, for the term of enforcement, they could prohibit access with a fob.
Yes.
That is one of the enforceability issues. So you know, it's a fair amount of work though to be tracking these things. But the other concern that I have, which, you know, the Strata Corporation may run up against the wall to discover, no, you can't use this video surveillance for the purpose of bylaw enforcement, is where did they get their surveillance bylaw from? And does it actually reflect the limitations of PIPA and recent decisions under the CRT? That's a bigger issue. And I think that everyone should look closely at their privacy bylaws that they probably wrote 5 or 10 years ago. It's probably time for a good upgrade on those.
Absolutely. And the Privacy Commissioner publishes guidelines and updates those guidelines quite regularly to help strata corporations and property owners figure out what they can do with respect to video surveillance, fob, general information collection. And it's funny, this story was, this scenario was based off of a recent decision from the CRT, and there was a similar one from the Privacy Commissioner's office where the privacy policies were outdated. They didn't actually contemplate this mechanism for bylaw enforcement. The strata was also unable to establish that it tried less invasive maneuvers before going to the extreme and using, in that case, it was video surveillance and fobs to regulate and curtail the activity. And so the strata needs to be really, really careful. I mean, these might be creative tools at their disposal, but they want to make sure that they have the language of the policies in place, their bylaws in place, that they can actually use these tools, pick up these tools going forward.
You know, I was going to say the Privacy Commissioner's guide for strata corporations is exceptional. And in section 19, it's a checklist of the limitations and the requirements for your bylaws. So if you're an owner in a strata and you're looking at your bylaws, go through that checklist. And if you can't meet the test of that checklist, I'm going to bet that your bylaws or your privacy bylaw is probably out of date and is due for an upgrade. But strata corporations use video surveillance quite frequently for bylaw enforcement to identify who the perpetrators are. But the other thing they do, which actually makes it kind of creepy for me, is they will have someone actually monitor the activity of people in the building. And that really violates my privacy as an owner when I'm coming and going. If an incident happens and you need to identify an incident because there may be a requirement for a police complaint or something much greater with respects to the safety of the building, you're probably going to have to go back to the video surveillance, but you need to articulate that you have that authority within the bylaw for it to be enforceable.
Yeah, this isn't just a subscription, a new channel that the Strata Council president can sit down and watch on the day-to-day, and some folks do.
I know they do it. You know, it's kind of like a whole new occupation for the curtain twitchers. It's
You're right. It's a little bit more of a exciting alternative to that. So, and I should say in the scenario that we've put up there today, the strata also got its wrist wrapped a little bit for having a guest sign-in sheet that required any overnight guest to register at the front desk and provide a copy of their photo identification, so their driver's license, their name, and the policy that they had in place, the privacy policy, said that the strata could keep that information indefinitely. And the commentary was quite understandably critical of that, saying that you're monitoring people's guests, and people will not think that that is a reasonable approach to trying to regulate short-term accommodations. That's a lot of invasion into your personal life in terms of who's coming over, when, how long they're staying with you. There's other less invasive ways to regulate these activities.
You know, from a marketing perspective, that has such a derogatory effect on anybody wanting to purchase into these buildings.
Yeah.
You know, I wouldn't even consider it for a heartbeat. Your personal privacy would be compromised constantly.
Yeah. All right, Josh.
Well, I popped on in now because I think this is a great opportunity to segue into our Q&A portion. So Claire, come on in. Nobody is going to allow me controls anymore, Lisa. I have been revoked, and for good reason. Although I may not have been the culprit, it's possible. Who knows? We have a ton of questions. I have certainly had the benefit and I've been grateful to be the host or the moderator on a number of panels, but the questions that are coming in on this one are next level wonderful. So I just want to remind everyone, we're here until 11:30. I am going to do my best to get to all of the questions within the time frame that we have. For those of you that are posting some, you have some other questions, please put them in the Q&A. If they end up in the chat, there's a high possibility they might get missed or overlooked. So please, if you've already put it in the chat group, copy them, put them back in the Q&A so we can hopefully get to them. So let's just start right off. I'll just start off at the top. This might be more of a comment than really a question, but Fanny had mentioned that there's an address on Burrard Street that was challenged by some owners at an AGM and at court and in arbitration. So there's no restrictions now on short-term rentals. So we could, I think you addressed that already. Was that the one you were referring to, Tony?
It was not, but I am aware of that one.
Okay, all right. Greg's got a question. He goes, my client has a condo and lives, works there 3 days a week. He also has a home on Bowen Island. And how does he go about establishing which is a primary residence?
Yeah, that's a good question. It comes up a lot. I mean, you can only have one principal residence through the province as well. So I'm not sure if Bowen Island, there's different areas that the province has enacted for speculation tax as well. So there's a lot of different layers to some of these things. It's not quite so a black and white answer. So we would have to have a specific conversation around what that may look like. It's not just documentation, it's sort of support from other areas and understanding what the business would look like and how much time they'd spend there.
Okay, wonderful. Thank you. Randy's wanting to know his understanding in Vancouver, short-term rentals license is required for any tenancy less than 30 days. This license needs strata approval. I'm not sure if that's a question, but without this license, short-term rental is not permitted and subject to the City of Vancouver enforcement and fines. Strata can also fine owners. Is that correct? That would be.
Who wants to tackle this first? I mean, the licensing requirements are there. So from a strata's perspective, if somebody is engaged in an unlicensed activity, then there are other bylaws you can lean on to enforce or prohibit the activity because they have violated another municipal bylaw. So there is a mechanism there for the strata. From my perspective, and I guess what Tony and I have been emphasizing today, though, is the best recourse obviously is through having a specific bylaw that prohibits the activity as well, because the license might just be missed paperwork and maybe that's acquired later. And so we want to make sure we have sort of two levels of enforcement there.
Okay.
I think to add to that though, Josh, one of the conditions of the city bylaw that we're going to run into some complications with is the requirement to get permission from the strata, a document of some sort that consents to the use for the purpose of short-term accommodation. And when you look at the number of small stratas we have across the city, duplexes up to about 6 units, many of them don't have short-term accommodation bylaws, but they also function in a very informal way. I see frequently on listings or in descriptions where this is a non-conforming strata. There is no such thing as a non-conforming strata, by the way. It's incorrect use of language. This is a strata corporation that's not complying with the Strata Property Act. They're not having an annual meeting, they're not insuring properly, they're not calculating strata fees, they're probably not maintaining and repairing properly. And the difficulty that we see arising from this, especially duplexes and triplexes, where the resident owner actually does have the ability to have, because they're larger units, they have the ability for short-term accommodations, is that nobody else within the strata is prepared to sign a document giving consent. Or the owner of the unit who's wanting to rent is often the president of the strata council because there's so few units, but the other two parties don't want to give consent, and yet they have no bylaw that prohibits the short-term rental. So, I think over to Claire, I don't know how the city's going to struggle with that or address that, but the smaller stratas are going to be a bit of a challenge on that front.
Yeah, no, it is a good point, Tony, and thank you. We have across this, and we consult with our legal team on these ones as well to make sure that we're understanding what is and isn't permitted. We have made the efforts to reach out to neighbors to understand what's going on in some of those smaller strata properties as well. So if we get a complaint saying they're not allowed to do it, they don't have permission and things like that. So they are, I hate to say case by case all the time, but some of these really do have different nuances. We want to make sure that, a community impact is a really important thing. So we do reach out and have some specific considerations.
Okay. There's a follow-up question here that this could be a good one for all three of you. Here we go. Can we address the fact that Vancouver requires short-term rental license or subject to, hang on, this just moved on me, or subject to fines of up to $100 a day, the City of Vancouver 1% vacancy tax, and then there's the 2% BC speculation tax and exemption from federal primary residency tax. How do we tackle that? I guess is the question that this person wants to hear an answer to.
So I'm maybe not sure what to tackle in regards to it.
Let's say it one more time. I know there's a mouthful there. Do you want me to say it one more time, and I'll go a little slower? Can we address the fact that the City of Vancouver requires short-term rental license, or you end up being subject to fines of up to $100 a day? There's a City of Vancouver 1% vacancy tax. There's a 2% BC speculation tax and exemption from federal primary residency tax.
Yeah, I mean, what I can say, and I'll actually clarify this, if you are found non-compliance from a city's perspective, we can fine up to $1,000 a day, just to clarify. So it's more than 100. But I think what the big item there is that they're all supporting that people have to live in the residences that they're claiming as a principal residence. That's what all those different regulations are in place for. So I can't speak from provincial and federal level, but I think it's just really to focus on, we have housing crises in different areas throughout the province, different areas throughout the country, and all these things are put in place. And I know there's a lot of layers to that, but they're all done to support, to have affordable housing for people in the cities that they live in. I don't know if Tony and Lisa want to add more to that.
Well, I think it's important that investors realize this is going to get very expensive if you're not complying with the Strata Corporation bylaws and the city bylaws and regulations. It could, from the perspective of daily penalties, it could be costing you several $1,000s a day in fines and penalties for not complying. And I think what we're going to see now in the next 6 months to a year, that these investors who live in a building, but they own 5 to 10 units in the building and run them like a hotel for short-term rentals, are going to suddenly discover it's not feasible to do this, given all the potential fines and penalties that are there. And so, I think that investors need to step back and say, is this really worth it, given the risks that we're exposed to?
Agreed, totally. I'm going to keep us going because we've got quite a few questions to address, and there's some good ones. John's asking, if I had an apartment and periodically secured some short-term rentals during the year, how does that relate to the vacancy tax calculations for properties that would otherwise be vacant for, say, several months of the year?
What I can say is, I mean, sort of the same sort of messaging from the city's perspective. We would just make sure that you live in the property that you're having short-term rentals in. So sort of that from our lens, we're really looking at it. If you live there and are able to have short-term rentals to support while you're away and things like that, as long as you're adhering to the bylaws from city perspective and aware of all the other ones that need to be in place from a strata perspective, that's fine from our perspective.
Okay. Got it. This one's, I think it may have already been brought up, but let's just ask the question again. Greg would like to know, if Strata's bylaws state rental and not the word accommodations, are they needing to rewrite their bylaws?
Yeah, I mean, it's a problem depending on how the bylaws worded. And so this isn't, I know we say short-term rental and it's common language. It's frankly, it's common in the regulations. It's common when we talk about short-term rental bylaws, but your bylaw needs to say more than rental. It needs to explicitly delineate what you mean by the activity, whether it's a vacation use, hoteling operation, timeshare, bed and breakfast. It needs to be very, very clear as to what activity and whether it's renting out all or part of a strata lot as well, whether it prohibits the advertising alone. And so, yeah, I mean, dive into your bylaw. And if you find that your bylaw is brief, it's probably not big enough.
Okay, wonderful. Here's a fun question, a little less related to the topic, but fun nonetheless. Is it okay to compensate strata council members if they do a lot of work for the strata? I thought you would all get you'd enjoy the question.
No, it's a good question, Josh. Remuneration of strata council members is actually explicitly permitted in the Act, but it requires that it must be either approved in the annual budget, it's in a bylaw, or by a 3/4 vote. And that generally arises when there's a major project and one council member is going to take on a heavy workload. And the strata corporation is going to say, look, until this project is done in the next 12 months, we'll pay you $500 a month or something like this. So compensation of council members is permitted, but it should be explicitly detailed. Whether it's approved in the budget or the bylaws or in the resolution as to who is getting paid. For example, what position? The treasurer shall be compensated $200 a month. It's a way of attracting people to strata council sometimes. It's also a way of keeping council members for some longevity, but it can easily be abused if who is getting paid, how much they're getting paid, and for what purpose is not very explicitly detailed. And that then creates problems. Don't leave it up to the discretion of council to decide who's going to get compensated. Make sure that the bylaw or the budget or the resolution are very, very detailed. The other thing that the corporation needs to remember is if you're compensating council, you probably have to issue a T4 as well. There are going to be financial tax implications associated with this. This isn't money under the counter. This is revenue that the individuals are obliged to claim, and it's a revenue that that's being paid that the corporation is required to report along with their tax returns. As a whole bunch of people just said, what tax returns, who are on the call, but strata corporations must file an annual tax return like every other corporation in the country. But I know, Lisa, good idea, bad idea?
Well, I don't know if it's particularly motivating. Like, I have to say, I see the worst case scenarios hit my desk. So it's when the abuses happen and when council is paying themselves, but they don't necessarily have the proper approvals to be able to do it, or it's a bit vague in terms of what compensation or level of compensation. I mean, anyone who served on strata council knows that there is not enough money in the world to compensate you for the time and the headache of assuming that position. And so I think it's certainly, as Tony said, it's permissible, but whether or not it's practical for you and your community is a question for your community.
Yeah, and just as a follow-up, I'd have to say, I have never seen this be 100% successful.
Yeah.
Sure. There's a follow-up comment to this from another realtor saying, if you're a realtor and you're sitting on your strata council, then you cannot be paid for sitting on strata as per the realtor rules. I can't say that I've read that specifically, but I'll put that out there and we can all check it out. Brandon's wondering, does a bylaw preventing rentals actually prohibit short-term rental accommodations?
No, it does not. If your bylaw just says no rentals are allowed, you're not covered. So short-term accommodations are not rentals. And so if your bylaw is very sparse and it just says no rentals are allowed here, you're going to be out of luck if you want to try and enforce it later.
Okay. Randy's wondering, for you, Tony, why do you need to pass a bylaw when the short-term rental of Vancouver anyways requires a license? So you can get approval for a license. Why would a bylaw need to be created?
Well, the City of Vancouver license requirement deals with the city's regulation with respects to the personal property. It doesn't deal with the corporation perspective on what they are limiting. So, it doesn't. The regulation won't prohibit a strata corporation from permitting short-term accommodations. If the strata corporation wants to prohibit short-term accommodations, the only enforcement they have is a bylaw. And if they don't have the bylaw in place, fining, enforcement, orders, eventual court orders, which could be potential, and enforcement or an application to the CRT, none of those tools would be available for you. And the individual could very well be complying with the City of Vancouver requirements, but the strata corporation may still want to prohibit short-term accommodations.
Got it. Okay. Here's one you might be familiar with. Vera's saying the Innkeepers Act used to be specific on the term of occupancy. I haven't checked it lately. Weekly occupancy versus monthly would change the status. Is this still happening? Who's familiar with the Innkeepers Act?
I don't think I've ever taken a stroll down that act, so I have to take a back seat there on the innkeepers regulations there.
Yeah, and the Innkeepers Act has no enforceable application over strata corporations unless the strata corporation itself was specifically designed, created as a hotel.
Got it. Okay, there you go. Rod is asking, does hosting international homestay students fall in the category of short-term rentals if it's under 30 days?
Oh, Lisa, that's all for you to deal with, but it falls under your earlier deal with
Yeah,
bylaws.
it'll depend. It depends on what your bylaw says. So technically, and I'll defer to Claire on the city's perspective on this, but your bylaw can be broad enough to capture housing swaps or homestays or whatever. The definition of what constitutes value or money exchange can be just in terms of babysitting somebody else's property. And so it doesn't necessarily mean that money has to be paid for use and occupation of the property. It could be some other value in exchange. So yeah, I mean, it will really depend on your bylaws. And if you include those scenarios or those types of home shares or vacation accommodation exchanges in there, you can certainly regulate it.
I wonder if it would fall in line as well with billets. If you're a family billeting hockey players for junior hockey.
From the city's perspective, there's ones specific in regards to homestays and lodging, which speak to specific rooms designated for these specific activities. Like short-term rentals are generally sort of marketed, advertised on these sort of larger platforms, whether they be VRBO, Airbnb, and things like that. So there are a lot of nuances, as has been mentioned. So it is really important to look at the city's bylaws, the stratas, all those ones when diving into some of these areas.
Okay, all right, thank you. Is a home swap considered short-term rental accommodations? I've heard of a situation where a condo owner was fined $1,000 a day for swapping their condo for a few days a month on a home swap site, swap site. Is that enforceable?
Well, one of the challenges, and I'll let Lisa jump in on this too, because one of the challenges we have with home exchange is home exchange has entered into a formality of business now with organizations that allow you, like timeshares, to build up points, to be able to use units in other places. And they might not actually be legitimate home exchanges. They might be that you've just entered into the pooling of all of the home exchange and allowing someone else from another part of the world that you don't know to access your unit while you go access somebody else's unit. So I think the crux of it is, and this comes down to a point that Lisa made earlier, whatever you prohibit or restrict has to be very clearly articulated within your bylaws. So to just say that short-term accommodations are prohibited doesn't prohibit home exchange. And the other side of that is strata corporations frequently won't approve a short-term accommodation bylaw because they're afraid that it's also going to restrict the ability of a home exchange, legitimate home exchanges in the traditional sense, where I have friends in England, they're going to come and stay in my place for 60 days. I go to stay in their place for 60 days. That activity is going to be prohibited. And many people don't have the luxury or the affordability to be able to travel without that flexibility. So there's a lot of apprehension around it. So what you want to prohibit or restrict needs to be very clearly articulated within your bylaw. And I, Lisa, I think you can add to that, because this is where the bylaws are really insufficient. Maybe the bylaw, it's 25 words, pretty good indication that it probably doesn't reach the mark.
Yeah, and also your bylaw can not only just enumerate what constitutes a short-term accommodation, but what's exempt from that too. So this is excluding these types of arrangements and being explicit about that as well. So the clearer that you can make your bylaw, the better it will be for enforcement. Consider that whoever is going to be reviewing this, so if the strata goes to the CRT later or goes to Supreme Court later or what have you, the judge, who's a stranger to your community, is going to look at this and saying, me as a stranger, how do I interpret this? What would a reasonable person interpret this bylaw to mean? And if there's any confusion as to whether or not your arrangement fits into that puzzle, then the answer will be no. And so, yeah, I mean, you have to be clear. And to echo one thing that Tony had mentioned at the beginning, we see a lot of bylaw swaps, so like bylaw exchanges, let's put it that way. So people will steal bylaws from other councils, or somebody council will, I saw one before where a strata corporation was selling off their bylaws as a source of revenue, which was very interesting. But it didn't fit with the community. And there's whoever is drafting the bylaw will have some consideration in terms of how does the language, what language do I need to capture what this community needs going forward. So, you know, home exchanges, bylaw exchanges, they all come with risk.
So just as an aside, while we're talking about drafting bylaws, and possibly there are people in here thinking our bylaws are easily 10, 15, maybe older, and we want to go and revamp them. Are we looking at a roughly about $5,000 for a revamp on bylaws? Any idea roughly what that would be?
That seems a bit expensive to me, depending on how many bylaws you have to review. And so I know that some law firms will offer a template, and then the council can look at the template, and it's billed at a lesser rate, and the council can build in what they would like to see. And the lawyer will say, well, no, this you can add, this you can't add. And so it's more of a collaborative process. I've worked with some councils where they want you to amalgamate all of the bylaw amendments and go through it in a sort of painstaking way. And so I suppose you could be ringing up quite the bill there. I think I'm going to give the typical lawyer answer, and it depends.
Okay, well, that's a great answer. I was recently quoted $5,000 to revamp our bylaws at a strata that I own a few places at. So that's why I asked the specific number in question. Thank you.
Oh, I see. Okay.
I'll be calling you later. Dawn is asking,
all right, deal.
Claire, I think this is for you. Dawn is asking, are condo home exchanges considered legal by the city of Vancouver, as in the $1,000 a day fine does not apply to this type of rental, even though, say, the condo building has bylaws that say you can't rent for anything less than 3 months?
Yeah, and I think it really goes on something that Lisa touched on. It depends on the wording. Rent and home exchange aren't always equivalent. And sometimes an exchange of, as Tony mentioned, we're seeing ones where it is the points-based system. So is that transactionary? As a general, home exchanges are allowed in the city of Vancouver. We're not trying to be a no-fun city by any means, and we support travels and things like that. But there are a lot of nuances. You know, it does depend on the exchange, the big thing here as well is that it has to be under 30 days. So that's a short-term rental, you know, like when we think of short-term rental accommodation from the city's perspective and that verbiage. But in general, they are allowed and supported.
Okay, wonderful. I just want to put this out there. We are now at 11:16 with 14 minutes to go, and without question, more than 14 minutes worth of questions and answers. So I'm going to do my very best to pick questions that may not have already been addressed. So here we go. Can a strata corporation force a new owner to serve notice on an existing month-to-month tenant just because the new owner needs to then go to the rental wait list? It seems to go against the Residential Tenancy Act. How much notice would be required? In this case, 2 or 4 months. What if the existing tenant does not want to leave and the new owner intends to rent out the unit? If the new owner goes to the rental wait list and their term comes up to rent to a new tenant less than a year later, are they opening themselves up to a lawsuit from the previous tenant?
Wait, there's a lot packed into that scenario.
There sure was.
There is a lot. So I'll maybe take a stab at that first. So if somebody is renting a month-to-month tenancy, so you could have fixed term, long-term leases. So for say a fixed term of 1 year is quite common, or you can have a month-to-month scenario. And by law, we have under the Residential Tenancy Act, you can rent for a fixed term. And once the fixed term expires, unless the owner is moving in and can take possession of the property, then it will naturally roll over month to month. If that tenancy is in violation of a strata corporation bylaw, then the strata can tell the owner, you do not have permission to rent, you are in violation of the bylaw, and enforce the regular rental bylaws in the same way. The owner can issue an eviction notice on that basis. Now there's protections in place for tenants that weren't aware that tenancies were not allowed by the strata corporation. Chances are in that scenario, the owner would be on the hook for a lot of compensation to the strata in terms of fines, but also potentially to the tenant in terms of their moving expenses if they need to leave. The other piece on there is landlords and tenants can always negotiate the end of their lease. So we always talk about evictions. You don't necessarily need an eviction notice to end a tenancy. You can negotiate something called a mutual agreement to end tenancy. So stratas, for example, when they apply a rental hardship bylaw and allow rental for a limited period of time. I know that this person was touching on the issue of, well, if it's a month to month, how can you regulate it? And as a condition of approving a finite rental period of time, you can require them to enter into a mutual agreement to end tenancy. So there's lots of ways that a tenant can end their tenancy, or a landlord can end the tenancy, and it might not end at the end of the day in terms of an eviction notice.
Okay, cool.
So
Thank you for
Josh,
that answer.
So
Yes,
Josh,
go
there's
ahead.
one little variable in this. If the strata lot is sold, what happens to the tenant? And for some crazy reason, I don't know if they're new or if they've just been out there as sleepers, but we've suddenly seen a number of bylaws that say on the sale of a strata lot, the tenancy or the right to rent is terminated. It's not. Sale of a strata lot does not terminate a tenancy. And so that unto itself is problematic for strata corporations who have those bylaws. So to start with, they have an unenforceable bylaw, which is going to create problems for them. Then they need to deal with what's going to happen if they now have a bylaw that says you're on a waiting list, or there's a required eviction. They're not going to probably be able to enforce it. So it creates problems, potential problems for the new buyer, creates potential problems for the strata corporation, but it does not terminate the tenancy for the tenant.
That is a really good point, Tony. Yes, because I imagine most people would think automatically it does.
Yeah.
Yeah.
That's a common misunderstanding. We see it, and Tony and I chat about this quite regularly. A lot of people are under that understanding that when you sell your home, your tenant needs to leave, and that's not always the case.
Well, and I mean, that's a mind blower actually, because some people will have been, they're on the list, they're part of that limited amount of units that are allowed to rent. So of course, when they sell their unit, the next person on the list would get moved on. So that's the mindset. But what you just said is pretty fascinating. It's almost like a bit of a conflict. The tenant doesn't necessarily have to go if notice hasn't been served, but from the strata's perspective, the owner is no longer available for rental.
Complicated problem.
To say the least. Yeah. Thank you for that. Here's another one. What can we as realtors do if we sell a client into a building that allows short-term accommodations or rentals, though then does not provide a letter of authorization to my client? I've seen this in a few instances where they say they don't believe it's actually their primary residence.
I can.
Yeah. Go for it, Claire.
Yeah, we get these a lot. So when people are registering to get a short-term rental license through the city's website, it says, do you have strata authorization and can you produce a document? So that's the first thing, is to really encourage them that they have this documentation before they go into this this license. It has gone to CRT, a number of them, where the stratas have not actually given the authorization and that type of letter. And those have some specific repercussions from those outcomes. But we'll make the effort to call stratas and understand sort of what the consideration and why they haven't authorized that letter as well. So we're there to work with everyone and better understand it from everyone's perspective. Ultimately, if they can't produce a document and the strata has their reasons for not issuing it, then they don't comply with the city bylaws. So that they either won't get a license if they're in application status, or that their license will be suspended until they can provide us with that documentation. And I know there's a number of stratas that have started implementing their own principal residency considerations around making sure that they can get that type of authorization.
Okay, thank you. Russell's wanting to know, are strata leaseholds under the same regulations as strata freehold? Most of these leasehold rules were established in 1973.
Easy answer, yes. If it's a strata plan was created and filed in the land title registry, then it is under the requirements and regulations of the Strata Property Act and subject to the conditions of the lease with usually the municipality.
Got it. Okay. Thank you for that. Easy is good. Fanny would like to know, is there any chance Strata Corporation can put together an enforceable bylaws? Fanny would like to hear from both Tony and Lisa on this. Aren't most bylaws typically enforceable?
Oh no.
Well, then, all right, there we go.
You would
Josh
be
hopefully
surprised what you
says, yeah.
see.
Look at that
Fanny
optimism
asked
in
a
that
great
tone.
question.
Go ahead,
You
Lisa.
know what,
Yeah, a bylaw is only as good as its drafting and its application to a community. And so, you know, one might think works for a community, it might not work for another community. And so it's important to get them checked out as well. And so Tony was saying too, that you might have your bylaws sitting on the shelf for 5 years, 10 years. It's time to dust off the dust and see whether or not your bylaw is still enforceable. But yeah, I mean, at the end of the day, the CRT is filled with decisions that say your bylaw is not enforceable. And so that's a huge risk to a lot of communities.
all right, we are 6 minutes away now from concluding, and I'm going to go ask a couple more questions, and then I think we'll call it there. Can the city do back fines for violations of short-term rentals? So, i.e., if they've been violating it for 3 months and then they get a complaint, would the city ever fine them $1,000 a day going back 3 months, or only going forward? That's for you, Claire.
We have a requirement to find our own sort of identification of the violation. So we need the evidence through ourselves as well. So it's you know, a complaint is something that we investigate every single complaint that comes to the city, certainly in regards to short-term rentals. But for a violation to be identified, we have to be able to provide the evidence so that the person that we're sending the violation to actually sees it documented. So if it depends on what it is, whether it's marketing without a license or whether it's like noise is a bit harder to actually identify in regards to compliance or not. But we work with VPD, like we try and gather as much information as possible, but we need this specific evidence from our own sources to be able to identify a violation.
Okay, yeah, wonderful. Thank you. Jenny's asking, if a buyer purchased an investment property and the strata bylaws they don't mention that there is a short-term rental restriction, so it's silent. Can the investor hire an agent to look after for the Airbnb? Do they need to apply for a license? The property is located in Tsawwassen.
Sorry, I missed the question, and then I heard there was in Delta, so I can't speak to the Deltas.
I was way too fast. I dismissed it.
Sure.
Hang on. I got to go get it. If a buyer purchased an investment property and then the strata bylaws don't mention that there's a short-term rental restriction, so as far as they're concerned, they're good to go. Can the investor hire a property manager, by the sounds of it, an agent, to look after the Airbnb rentals or the applications, or do they need to apply for a license with you? Well, in this case, it would be Tsawwassen.
I'll quickly answer from a city perspective. The first thing is, it said it was an investment property, so it wouldn't qualify. Someone needs to live in that unit to get a short-term rental. But if someone actually did live in that unit, then you can use a property manager. So we did enact bylaws to support that people don't have to operate all their own short-term rentals, and they can actually hire someone else to do the management of their short-term rentals. But that also does require a city of Vancouver license specific in regards to property managers.
Okay, wonderful. I think this might very well be the last question we have. It's a big one. Bijan is asking, would the following use of property bylaws that is found in almost every strata be able to prohibit short-term accommodations in a city that does not allow them, or not allow them without a license? So I believe he goes on to say, or this person goes on to say, a resident or visitor must not use a strata lot, the common property or common assets in a way that is illegal or contrary to the government or municipal rules, bylaws, or ordinances. So, and I think that's the end, or that would be injurious to the reputation of the building or the strata corporation. I'm wondering if that language would then be their ability to prohibit short-term rentals.
Well, it doesn't explicitly prohibit that. It's saying that basically if somebody tries to use a short-term accommodation without a license, like if you're in the city of Vancouver and somebody's doing this and they're not meeting licensing requirements, then technically I suppose you could rely on that bylaw and say you're using your property in a way that is in breach of municipal bylaws. The challenge that I have there is often when I'm assisting clients at the CRT, they will look at, well, did the city actually take notice? It's what is an illegal activity from the city's perspective? If they're not enforcing it, then you as a strata can't enforce it either unless you explicitly prohibit the activity. And I'll defer to Tony on the reputational commentary and bylaws. I see that a lot, like don't do anything that would damage our reputation. I don't even know what that means. And so, I mean, does that mean, you know, wearing your hair in a certain way or wearing a certain article of clothing one day? I don't know. I might be offensive to most people. So I would be very, very cautious about using that kind of creative language.
Yeah, and you know, it's often interpreted when suddenly you discover that there's an escort service,
right.
We'll call it an escort service, being run out of one of the, or two of the strata lots in the building. But again, I think we have to go back to all of the decisions through the courts, through the Privacy Commissioner's Office, and through the CRT, if you really want enforceable bylaws, they need to be very explicit on what is prohibited and what is permitted. And it's the only way to have a fairly ironclad way of making bylaws that work for your strata corporation. But you also have to step back and say, all right, we have to enforce these fairly and equally against everyone. We can't privilege council members who are violating bylaws that we're not enforcing these against, but we're going to enforce them against the 5 people we don't like in our building, which is also a problem that we see frequently that occurs. You know, and so, you know, it's a combination of having an enforceable bylaw that is very articulate and detailed as to what is prohibited, what is permitted. It's explicit into the different types of activities, and then the practice of enforcement has to be applied fairly under every circumstance.
Thank you for your answers. We are at 11:29. I think I'm going to let Randy have final words here. He did post this in the chat. His takeaway is there seems to be a disconnect between strata owners, neighbors, city, provincial laws that don't want STRs versus those that want to run an STR, or realtors that want to promote STR income on listings. Should CREA encourage realtors to disclose the status of STR licenses, and or clear guidelines on what is required to run a legal licensed STR or B&B in Canada? Probably not really a question that requires an answer, more of a thought than anything. I would like to conclude because we are now at 11:30. Thank you, all 3 of you, for an incredible panel. This was content rich, information deep. There was a lot of learning that took place here, and no doubt we could go on for another hour with the questions and the answers that are going to roll out from this, but we do not have another hour. Claire, Lisa, Tony, it was a privilege to be in this chair and to listen to your answers and watch you go. It was absolutely wonderful. Thank you for your time.
Thanks for having us on. It was a pleasure.
Thank you very much.
You're welcome. You're welcome. I will just say before we go, we'd love to hear from all the people in the room with your feedback. When you log off, you'll get a pop-up link to our event today. Your feedback is valuable, so please share your thoughts with us. There are a few other events coming up, one on November 3rd, which is Beyond Sea to Sky Municipal Update. On November 24th, how to leverage video marketing and YouTube to double your real estate business. And on November 30th, we have our 2021 and beyond North Shore Municipal Update. Thanks again to all of you in the room that were here today. I appreciate your time, your questions, your thoughts. Wonderful, wonderful session. Thank you all.
Okay, thanks, Josh.
Thanks, Josh.